Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. As we had previously informed you, the Media Coalition has filed a motion to be heard as interested parties and motion to unseal records. The media's motion is now on the public docket for you to read. It states as follows. On July 2nd, 2025, Brian Kohberger pled guilty to the unalivings of 4 University of Idaho students and 1 count of burglary. Mr. Kohberger's plea sharply changed the Sixth Amendment fair trial, First Amendment balance in this case, and has rendered the primary justification for sealing records in this case moot. What is the media saying here? The media is arguing that that change of plea has now modified this prior balance between the Sixth Amendment and Mr. Kohberger's right to a fair trial and the First Amendment, the public's right to know, freedom of speech, the press's right under freedom of the press and the media to report to the public the goings on in this case. The media continues. Indeed, the infringement upon the First Amendment rights of the media and public through the voluminous sealing of records in this case is no longer justifiable, nor does it comport with Idaho Court Administrative Rule 32. If I may interject my opinion, I feel the media is being quite conservative when they say voluminous sealing. It is only when, ladies and gentlemen, you look at the case summary page, all 102 pages of it, and you see motion to seal repetitively filed and order sealing documents time and time again, that it is only then appreciated just how much information has been withheld in this case. The media continues. Rule 32 expressly allows for a non-party whose rights are affected by or who otherwise has a right to access information contained in a court file may move to unseal records in a case file. Accordingly, a coalition of media organizations, the Media Coalition, as interested parties, respectfully move this court for leave to file their motion to unseal records. See also the Associated Press versus Second Judicial District. This is when the media in 2023 went to the Idaho Supreme Court in an effort to set aside the gag order. And in that filing, the Supreme Court says both state and federal courts often permit the media to intervene in criminal cases on a limited basis, or at least file a motion as interested parties in the defense of public access and free speech, including in Idaho. It continues, the Media Coalition further requests the opportunity to present oral argument. This means at a hearing, ladies and gentlemen, on the issue at the court's earliest available opening. This motion is supported by the accompanying memorandum and declaration of Rebecca Boone in support of motion to be heard and unseal records. We will address both of those documents in a forthcoming Indie Zone podcast. Until next time, this is Kathy. Thank you for joining us today.